And now we are down to our last topic, which is the violation of wage orders. We have learned in the previous topics that wage, under Article 97 of the Labor Code, Section F, it stated that wage only applies to the compensation for manual labor, skilled or unskilled, paid at stated times, and measured by days, weeks, months, or even season. Let us also consider that wages vary according to places. As what we've learned, under Article 99 of the Labor Code, it stated that there is a regional minimum wages, classifying agri from non-agri, and it was prescribed by the regional tripartite wages and the provincial board. Let us also revisit what minimum wage is and its purpose. By definition, it is the lowest wage rate fixed by law that an employer can pay his worker. And what is its purpose? Well, it is to reduce the evils of the setting system by the employers. To ensure that the guidelines of the wage be followed and not be abused, Article 120 and 121 of the Labor Code are created. And even if the Regional Tripartite Wage Board has the power to issue wage orders, it will still be under the review and approval of the National Wages and Productivity Commission if such order will be approved. Let us now define what wage order is. Ordinarily, wage order refers to the order promulgated by the board pursuant to its wage-fixing authority. And under the Labor Code, wage order is whenever conditions in the region so warrant, the regional board shall investigate and study all pertinent facts, and based on the standards and criteria herein prescribed, shall proceed to determine whether a wage order should be issued. Now, what happens when a wage order is violated? According to RA 6727, the employer concerned shall be ordered to pay an amount equivalent to double the unpaid benefits owing to the employees, provided that payment of indemnity shall not absolve the employer from the criminal liability imposable under this Act. In continuation, if the violation is committed by a corporation, trust or firm, partnership, association, or any other entity, the penalty of imprisonment shall be imposed upon the entity's responsible officers, including but not limited to the President, Vice President, CEO, General Manager, Managing Director, or Partner. Also, failure or refusal to pay mandatory wage increase is considered a criminal offense under Republic Act No. 8188, approved on June 11, 1996. The violator may be sentenced to imprisonment of not less than 2 years nor more than 4 years. He may also be punished by a fine of 25,000 to 100,000. Moreover, he shall be ordered to pay an amount equivalent to double the unpaid benefits owing to the employees. Another governing law is the DOLE No. 10 series of 1999, or the Guidelines on the Imposition of Double Indemnity for Non-Compliance with the Prescribed Increases or Adjustment in Wage Rates, which they define violation as refers to the refusal or failure to pay an employee of the prescribed increases or adjustments as may be established by the regional director. Another governing law, double indemnity, was also defined, which refers to the guidelines on the imposition of double indemnity for non-compliance with the prescribed wage rate or adjustment, which was not paid by an employer, which they define violation as twice the unpaid benefits, refers to the refusal or failure to pay an employee of the prescribed increases or adjustments as may be established by the regional director. Let us now illustrate this in the case of Producers Bank versus NLRC. The case here is that a wage order was already issued. It already credited the wage increase granted before its effectivity as compliance. However, Producers Bank Employees Association and Producers Bank entered into a collective bargaining agreement providing for a wage increase, which was to take effect retroactively before the issuance of the wage order and made chargeable against those ordered or legislated by the government. Now the issue is whether or not the credibility provision was valid. The court then ruled that the credibility provision in the wage order is valid. It is based on important public policy, that is, the encouragement of employers to grant wage and allowance increases to their employees higher than the minimum rates of increases prescribed by statute or administrative regulation. Lastly, we'll talk about its jurisdiction. For the trial court, it is only limited for civil actions. For RTC, the assessed value will only be $20,000 to $50,000, and for the claims for maritime and admiralty is only $100,000. It is also different from MTC and MCTC and other first-level courts. For the regional director, it is only limited for visitorial and enforcement power, and for the labor arbiter, it is only limited for unfair labor practice cases, termination disputes, and others as specified by law.